Hi, everybody. Welcome back to the second segment of this first section of the seminar. Hopefully you would have, from the first segment, gotten a better understanding of exactly what a company is, when you should be registering a company, and how you go about doing that, and understanding the importance of that company specifically in your role as a production company, producer, writer, or director. In this next segment, what we're going to be looking at is the assets of that company. And this is really where things kind of get a bit more interesting, and we start to look at how that company and the assets that it owns allow you to derive an income for yourself on a day-to-day basis. Just to give a bit more context to this, we often find that as much as everyone involved in this industry is immensely creative and passionate about what they do, the lack of understanding of when exactly you are creating rights and assets is usually detrimental, because unless you know when you are creating those rights, you don't really understand how your ownership is created and how you can transfer those rights and sell them to third parties. And that's where you make a living out of this. And often we find that parties get caught, kind of with their pants down because they haven't entered into the correct agreements from the outset of their dealings with third parties in the creation of rights. And then you end up with a fight down the line as to who's entitled to what, because we don't know who owns what and at what stage and in what shares. So the whole idea behind this is to really give you an understanding of, from the first segment, the structure of a company and where to house your assets, and when it's important for you to register that company to house those assets. And then from this segment, to understand what exactly those assets are, when are they created, what is the interaction of the company and the assets, and how do you utilize those assets to actually generate an income for yourself. Right, so let's go. So, as mentioned, once we understand the structure of a business, we need to consider what the business is creating. Is it goods, or is the business rendering services? And in doing so, what assets is the business looking to sell in order to derive an income? So with film and television production, regardless of whether the business is actually creating goods or rendering services, the asset that is involved is always going to be intellectual property, or IP, namely scripts and productions. Those are the main two categories. Obviously, there are certain other elements that are involved or other subcategories, but we're going to focus on those two for kind of ease of understanding. So what exactly is intellectual property? What is IP? So IP is an intangible asset and is something that is the result of applying your mind and creating an original or unique concept. Now, this is different to an otherwise tangible asset, which is something that you can physically touch or hold. Most people will consider bricks and mortar. So that's why I've said that an asset from a production perspective is always going to be IP, regardless of whether or not it is goods or services. So when we look at goods, we're going to look at the actual production that gets produced. That is not something physical. It's not bricks and mortar. It's actually an element of data. So service, likewise, is in writing a script, for example. That is a service that you might be rendering to a third party. But again, the asset that it creates is something that's intangible. Yes, we can pick up the paper, but the words on that paper can be transformed electronically to Word. It's an intangible asset. So there are different types of intellectual property. We would have heard of trademarks, patents, design, and copyright. So a trademark is something that gets registered by a business if they've developed a product. Similarly, you have a patent, and a patent is usually utilized when someone has come up with a specific formula or a new product that has various design elements and engineering behind it, and that process has to get registered to ensure that someone else can't go and mimic the chemical composition in this product, for argument's sake. Likewise, from a design perspective, if you've come up with a particular design, you've developed a new form of chair that knows how to balance on 2 legs because of your particular design, you can register that design. The last category that I mentioned is copyright. And this is the one that's absolutely important to all of us in this industry because that's what we're dealing with on a day-to-day basis. The nice thing to know in relation to IP in general, in particular copyright, is that there's various forms of legislation that actually provides you with protections for that copyright, because you want to know that your asset is protected and someone can't come along and actually just steal that idea, concept, or other form of IP from you. So there's 2 elements that we look at. The one is the Copyright Act and the Copyright Amendment Bill that's in place that provides legislative protection. And the second is the ability to actually register that copyright. So CIPC, the entity that we dealt with company registration, actually allows for registration of copyright, but only for films. It doesn't allow you to register other elements. So if we take a further look at copyright, what exactly is included under this umbrella term of copyright? So it includes paintings, literature, art, music, and film. Obviously, for the most part, the 2 elements that are important for us are literature and film. So copyright is the only form of IP which does not have to be registered in order to actually have the protection of legal protection of that right. Why? This is because you obtain your copyright over your work, over your IP, the moment that it's created. So if you are writing a novel, for example, the minute that you sit down and actually put pen to paper and start putting those words down, there's an automatic copyright over those works. So you're automatically protected. The flip side of this is really, how do you enforce that protection? Yes, it's all fair and well that it's automatically protected, but if someone comes, to my house today, sees what I've written and goes and takes that, mimics it on their side tomorrow, how do I go and actually protect that and enforce those rights? Well, it's a bit of a tricky situation because you have to be able to physically evidence that you produced those works first. So what a lot of people end up doing is, if you do create a work, going to some form of central bank in order to register that script, for example. Likewise, you can do something way more simple and email a copy of it to yourself. Then you have some form of track history to actually prove your ownership. So if there's ever a dispute over that copyright in the future, you can go back and show the exact point in time when it was created, and prove that you were first. So those elements are actually, from a practical perspective, quite important. If we look at the lifespan of a copyright, in relation to literary works, artistic works, and musical works, the lifespan is 50 years from the death of the creator. So if you've written a novel, you have all the rights to that copyright. You hold full rights to the copyright for 50 years from your death, which means that basically during that period, your estate would collect any incomes derived from that copyright. Once those 50 years lapses, that essentially then becomes public assets, and anyone can utilize that without having to remunerate you or your estate. In particular relation to film, the lifespan of the copyright is 50 years from the end of the year in which it was lawfully made available to the public or published. So if you've produced a feature film and you've gone and shown it commercially to the public, or not even commercially for that matter, but you've shown it and you've aired it for the public, then your copyright would end over that 50 years from the date that it was first aired. So if we look at ownership of a copyright, we ask ourselves the question, when exactly is a copyright created? As I've mentioned previously, that right starts the moment that you put the pen to paper, and you automatically have that protection. But what happens in the circumstances when it's not just you? You're sitting around a table, you're in a writer's room, and there's a whole bunch of you that are sitting together working to actually produce one work, one script. Then in that situation, what you have is actually multiple creators. And each of those creators is an owner of that copyright jointly. There may, however, be a question of the contribution of each of those creators to the final work. So there might be two main writers and two parties that came in and only provided a bit of input down the line. So you may have a situation where the two main writers are each essentially the 40% owners, and the two end writers that came in with minor contributions have 10% each. And it's very important to understand this from the outset, because if you do not capture those rights and make a proper record of who owns what from the outset, you essentially line yourself up for issues in the future with regards to who owns those rights and what you're entitled to do with those rights and how you get compensated for that. Similarly to multiple creators, you might not all be sitting around the table at the same point in time. I may produce a script and I might hand it over to Susan on my left, who's going to a week later go and add a contribution and do some editing on that script. Then likewise, Susan hands it over to Mike 2 weeks later, who also does some editing on that script. Still, what we face is a situation where I might have created this original script, but the moment that Susan has added her contributions, she has added value. So she now owns a portion of that script based on the amount of her input. Same situation with Mike down the line. So each time there's a party involved, it's important to actually contract with those parties. So if you have an intention of writing a script and you know that there's going to be 4 of you sitting down together and doing it, then either at the time or prior to actually starting to create the work, you can sit down and contract to say who's going to be involved and what their involvement is, and the percentage of that involvement and how they would get remunerated for that or paid for that contribution. Or the minute that you finish that work, it's important then to also ensure that that contract is in place. Then there's no question marks. Then everyone knows what they've done. They know what percentages there's, what they're entitled to, and they also then know what they're allowed to do with those rights in the future. So this really brings us to understanding what is known as commissioned works or work made for hire versus assigned works. So with the creation of copyright, because that right commences the minute that pen is put to paper, if you create something, you are the automatic owner. So if you're going to be writing a script and it's my concept, but I want you to assist me in editing that script, I have a choice to either say to you, 1, I'm going to commission you to work on the script, and you are providing works made for hire. You are essentially a hired gun. I'm paying you a fee. You're going to render services, but I will at all relevant times have ownership in those rights. You will never have any ownership in the rights because it is commissioned works. The other side of that is if I say to you, you go ahead and edit the script. Once you've finished editing it, I will then have to acquire those rights from you. So when you're busy with the work, you will be the owner. I will then acquire or purchase those rights from you afterward. And that is done via an assignment. Preferably, whenever working with parties where it's your concept, it is always preferable to work on a commissioned basis. Why? Because you want to ensure that there's no dispute about those rights after the fact. You want to know upfront that no matter what that person is doing, they're doing it on a paid basis, rendering the services, but you always retain those rights. And this is very important from a contracting perspective, because you have to, in your contract, stipulate that the works are commissioned works, works made for hire, to ensure that that party understands that they will never have ownership in that right. They are simply providing you a service for a set fee. And this becomes more important when we start looking down the line at chain of title, which we'll get to later on. So understanding the difference between when those rights are created, who owns those rights, and on that basis, deciding if it's going to be commissioned works or if you're going to take assignment of those works down the line. So again, if we just look at how copyright is transferred, this is massively important for understanding how you generate your income, because you cannot sell a right that you do not own. So again, You need to understand the difference between having someone do work and you buy it later from an assignment perspective, or having works commissioned where you pay the fee, and it doesn't necessarily have to be upfront, but they know that they're being paid a set fee to render services, but you will always retain ownership and rights in whatever works they create from those services. So now that we understand what the assets of the business are and how those assets are created and transferred in order to generate an income, we can consider what a production company actually aims to do. Answer's pretty simple, right? Produce films, TV series, documentaries. But how exactly does a production company do this? Well, the first step is, if you want to make a movie, you need to find some IP, some intellectual property that is actually going to make good content for your production. So most people will do this by, it might just naturally happen. You might be reading a book and be absolutely inspired by that book and think that this is going to make an amazing movie. But how do you do that? You have to acquire those rights. Similarly, if you're going to be looking at creating a TV series or a film or a documentary for that matter over someone's real life story or a situation that is played out in the news, if you come up with a concept for a reality TV show, if someone has pre-written a script or a screenplay, all of these categories are rights, and you have to acquire those rights in order to actually be able to produce. Why? Because again, you cannot produce a film or a TV series based on intellectual property that you do not have the rights to. If you went ahead and did that, that would be a breach of that person's rights, and they would be fully entitled to sue you because you've stolen property of theirs and utilized it unlawfully, and that would have caused them to suffer financial harm and damages. So how do you go about doing this? You have to conclude an option and assignment agreement with the owner of those rights. So again, if we have to utilize the scenario where you've read a book, you're inspired by this book, and you decide this is going to make an excellent movie, what do? You have to first of all go and approach the author of that book and find out who has the rights, because often if it's published, those rights might sit not with the author but with the publisher. So that's an important distinction. Sometimes people find themselves in a situation where they've entered into negotiations with an author of a book only to find out later that the author doesn't actually hold the rights. It's the publishing company that holds the rights. Therefore, the producer would have had to enter in the contract with the publisher in order to get those rights optioned. So as mentioned, the agreement that you would conclude in those circumstances is an option and assignment agreement. Once those rights have been acquired in terms of the option and assignment agreement, the production company will then develop those rights, that IP, into what is the final script that it ultimately uses for the production of the film or the TV series. So in the circumstances that you have the option, you now need to look at, are you doing a film or are you doing a TV series? Who are the parties that are going to be involved with that? What locations are you going to be using? Most importantly, drawing up the budget for your production, and then looking at how you're going to get that budget financed. So those are all your production steps. And we will deal later with what happens in terms of the actual option agreement once you have those steps fulfilled. So finally, we've got the rights, okay? You found the rights that you want to utilize. You've then gone ahead and secured those rights in terms of an option and assignment agreement so that you are entitled to go ahead and develop and ultimately exercise that option in order to produce the film at the end of the day. Finally, your next step would be to appoint third parties to actually film the production, on the ground production, your cast, your crew, your location agreements, all of those elements that you have to contract with those parties for to actually produce the film. And then once you've got that film made, it will ultimately then be sold to various platforms, broadcasters, networks, and so forth. So once we understand all of those aspects, there becomes an important term that is really crucial in any production and is often overlooked because people don't understand what the assets of a company are, what the rights are that you're dealing with. And this is all held under the term chain of title. So what exactly is chain of title? Well, it's essentially the chain of agreements which proves that the producer holds all the rights to their film or television series. So again, you can immediately understand why it's important to understand where your right is created and what happens to those rights afterwards, all the way through until the point that those rights are utilized to actually produce a film. So what is usually included in the chain of title agreements? Well, as mentioned, we've got the option and assignment agreement. Why? Because you as a producer have approached the author of the novel, who holds the rights, who initially created those rights, and you've optioned those rights from them in order to be able to go and produce your film or TV series. But what happens in the meantime? In the meantime, you've got to get a script writer on board, because we can't take a novel and just utilize that directly for the production of film or TV series. It has to be developed into a script. And who are the parties involved with that? Script writers. So you have to have script writers agreements in place. Again, ask ourselves the question of why. And that is because your script writers, when they are editing that novel and developing that script, they are in turn creating new IP, and they will own that IP unless you have contracted with them on a commissioned basis to ensure that you at all times own the rights. Then the third rung is directors' agreements. And again, you might feel that this is a bit of an anomaly when compared to an option and the script writers, but you have to bear in mind that your directors will often come on board to a production relatively early and actually be involved from a creative element in developing that script. So again, we need to ensure that a director's agreement is done on a commission basis to ensure that you hold all the rights and there are no third parties sitting, holding, clutching onto portion of your rights. So let's look at each of those agreements. First of all, we will start with the option and assignment agreement. So, we as a firm draft these agreements on a daily basis. They really are the beginning point of any production, because if you don't hold the rights, you can't produce the film. So it's vitally important to understand what is included in option and assignment agreement and when to get those agreements concluded and in place. So if you don't understand what an option and assignment agreement is, let's look into that. An option is the right, but not the obligation, to acquire the IP at a future date for an agreed price. So you as the producer read the novel, decide that you're interested in the novel and want to produce a film based on that novel. So you ask the author or the publisher if you can have the option to purchase the IP and the rights in that novel at a future date for a set price. So who are the parties involved? It's the owner of the IP, the author or the publisher of the novel on the one hand, and the production company or the SPV on the other hand. Why do we need to have this option? Why don't we buy the rights outright? Because we should all understand that you don't wake up today, read a book, and decide that you're going to start producing the movie tomorrow. There's a number of steps that need to take place. And essentially, it's a feasibility exercise. You need to take time in order to, A, develop that novel into a script that can actually be used for production. And then B, you need to start looking at financially, what is the budget? What is it going to cost you to make this production? And how am I going to get that financed? How am I going to finance that budget? Which parties can I bring on board? And that takes quite a significant period of time, which is why we have an option period. And that option period can range anywhere from a year to 3 years, that initial option period, to clarify. So that's the party, the producer, saying to the author, I really want to make a movie about your book, but it's going to take me about 2 to 3 years in order to actually get my ducks in a row and see that I can feasibly make this movie, that I can get the finance together, and that it is possible. So we also usually provide for option extension periods. So you might have an initial option period that's about 2 years, and then you will say, I also want the option to renew. So if I'm not able to get all my ducks in a row within the first 2 years, but I'm making progress, I will then like to notify you that I want to renew that option period for another 12 months. So it's usually commonplace to find an initial option period and then 2 renewal periods, usually about a year each. Again, these periods are all part of a commercial negotiation between the parties. So as much as I'm using the examples of 2 years and a year, these can be negotiated to any time periods that are agreeable to the relevant parties. So once we know what our option period is, we've got to look at, why is the author just going to hand these rights over to you for that period of time? And the answer to that is usually because they're going to receive a fee. So there's multiple ways of structuring these deals, but let's look at quite a straightforward example. I approach you as the author of a novel and I say, I want to make a film based on your novel, and I'd like to have an initial option of 2 years and 2 renewal periods of a year each. I have to negotiate a fee with you that is a reasonable fee for purchasing that novel. And that fee can vary widely, and it really depends on the quality of the novel that you're purchasing, how well known the author is. All those factors will, and ultimately what you're looking to produce as well, and what type of budget your production is going to be. You know, a 1 million rand production is completely different from a 100 million rand production. And obviously the fee that you're willing to pay for the option would be dependent on that. So your option fee can be structured as follows. In order to purchase and get the option, I will pay you, for example, 10,000 rand now. And every time I need to extend in terms of the renewal periods, I'll pay you 10,000 rand as well. What are you actually paying for there? Well, you're paying for the exclusive right to the option. So the author and the holder of the rights is not entitled to give those rights to anybody else during that option period. So it essentially gives you an exclusive window to try and get your production off the ground and see that it's feasible, without having to worry about the fact that the author has now also gone and sold it to John down the road, and he might be able to get his finance and everything together quicker and actually produce this film before you can. So you pay for that exclusive period. So you'll pay a fee for the option. But as mentioned, that option period is just to allow you to actually see if it's feasible to make this production during that period of time. Right, so what exactly is your option fee? What are you paying for? So you're paying for that exclusive period, but remember that what we are doing during that period is essentially testing the feasibility and seeing whether or not we can get this production off the ground. Can we determine exactly what the budget is? Can we determine if we can get the finance together for that budget? If we can't, then we cannot exercise the option. And that is the point where you actually take assignment of those rights from the author. So to take that back to how the fee is involved, you will usually pay an upfront option fee. As I mentioned, 10,000 rand for the initial option period and potentially 10,000 rand for each extension thereof. And then when you are ready and you know that you can get this production off the ground, you then exercise your option. And at that point in time, you pay the lump sum, the big amount. That is your exercise fee. And why we pay that lump sum at the end, or usually prefer to do it, is because when you first take option, you don't really have finance for your production as yet. You don't have access to funds unless you've obtained development funding. And therefore, you want to ensure that that exercise fee is only payable down the line when you actually know that you're going to have a bit of money in the bank and essentially received finance from one of your funders to pay that fee. So if we look at the other elements involved in the option agreement and what's important to discuss and negotiate, you need to look at exactly what rights you are looking to take from the author. So really what you need to think about is the fact that when that author has created the novel, the IP, it's essentially like a cake. And that cake can be cut up into many different slices. And each slice represents a different subdivision of rights. So if I write a book, I can be approached by you as a producer who says to me, I want to make a film based on your novel. And I'm absolutely happy to do that. And I sell you that slice of the cake, being the rights to produce a film or TV series. But I still retain the rest of the cake. And I might be approached by someone else who decides that they want to develop a comic strip based on that novel. And I can sell the rights to create a comic strip as a separate slice of that cake. I can also retain the rights to a theatre production based on that novel, for example. And you can think of all these different subdivision of rights. So your option agreement will be very specific in terms of which rights the author or the owner of the IP is actually optioning over to the producer. And likewise, which rights are reserved, are held back by the author. And with those reservations, that author might say, okay, I would like to reserve the right to, option the rights to develop a comic strip. And you would note that down in the contract. Or you would just be specific enough to say it is simply only the rights in relation to film production, television production that are being handed over. So, for example, I've had a scenario recently with an option agreement where the author decided, the author was the writer had written a script and had decided that they wanted the right to publish that script. And let me tell you from the outset, this isn't necessarily a common request, but in the circumstances that this particular writer wanted those rights reserved, and my client was amenable to that, we agreed to have those as reserved rights, the right to publish the script, but we included what is called a holdback. And that's to ensure that that reserved right is held back for a certain period of time and cannot be enforced for a certain period of time. So in that specific scenario, as much as my client was happy to allow them to retain the right to publish the script at a later date, they wanted to ensure that the publication of that script did not interfere with the actual production and the commercial viability of that production down the line. So we included a holdback to say that that right, that reserved right, can only be utilized a certain period after the film has been commercially released. So then we know it's not going to interfere from a commercial perspective with the release of that film. The second agreement that we spoke about in the chain of title is the script writers agreement. So again, this really all emanates back to the creation of rights. If you've gone and optioned the novel, you need to take that option period in order to develop that novel into a script that is workable for a production that's ready for screen. So in order to do this, your production company has to appoint writers. So you're going to have a script writers agreement concluded by your production company or potentially your SPV, as well as one or multiple script writers. And again, this is done on a commissioned basis, a works made for hire basis, because you want to ensure you've now got the option. And now when you start adding to those rights and creating separate IP in a script, that you are always the owner of the rights to that script. So you are going to commission writers to develop that script for you. So all rights created by the script writer are going to be owned by the production company. The script writer is merely rendering a service for a set fee. But let's look at what terms are now included in the script writers agreement. So firstly, you want to be specific in terms of those services set out. What exactly are they going to be writing for you? If it is a script, how many drafts of that script and how many revisions are you going to be entitled to? If it is a TV series, which episodes are they going to be responsible for writing? who's got to produce what at what point in time. Hand in hand with what those services are, we want to be clear as to when they need to start rendering those services and when they need to finish rendering those services. So if we have to utilize the example of a TV series with multiple episodes, when do they start drafting those scripts? And you would say, if the agreement commences on day one, we need to know, and that's today, we need to know that the first episode needs to be presented to you on the, first day of July. Sorry, Nadia. Right, so if we have to look at what the services are that are being rendered, we need to then consider the timelines that those services are going to be provided in. So if we have to utilize the example of a TV series, we're going to say that there might be multiple writers involved, and writer 1 is responsible for episodes 1 and 2. Writer 2 might be responsible for episodes 3 and 4. But we need to set up the timeline parameters for each of those writers. So writer 1 is now responsible for providing episodes 1 and 2, and we say to them that you need to present episode 1 by X date and episode 2 by Y date. And likewise, if there's going to be revisions, you want to set out the time frames so that there's no question between the parties as to who's responsible for what and when they are required to do that. You don't want to be fighting with your script writers to do their work at the end of the day. Likewise, we look at what they're going to be paid, so the fee and the payment date. So again, it's very important to understand what the budget of your production is, and to understand what is a reasonable fee to be paying your writers, depending on what role they're going to be fulfilling and what services they're going to be rendering for your production. And it's likewise important to understand how you're going to be cash flowing your production, because it's all fair and well to offer them a massive sum of money, but you need to know when you're actually going to have that money available in order to make payment of that fee. So with script writers agreements, what you'll often find is that there are two elements that might be involved as part of the fee: a capital amount, and then a percentage share of the producer's profit share. So let's just deal with the capital amount for starters. We would usually say that the writer is going to receive this capital amount of X, and then we would need to set out when they are going to be receiving that payment. So likewise, in the circumstances that you've been fortunate enough to acquire development funding for this production, you might have cash available up front. So you could say to the writer in that circumstance that they would be paid certain amounts, tranche payments, when they provide certain services. So on presentation and delivery of episode 1, you would then be given 20,000 Rand. On delivery of episode 2, you would be paid 20,000 Rand. On revision of episode 1, you'd get 10,000. On revision of episode 2, you'd get 10,000. Obviously, these numbers are simply just broad examples. So if you have development funding, you might be able to make those payments in tranches. However, you might very well find yourself in a situation where you don't necessarily have development funding. You have a writer that's willing to work with you on the project, but you don't have the financial means to pay them up front. In that circumstance, what you would do is you would offer them that capital fee, whatever the two of you decide is a reasonable fee, and obviously from your perspective as producer is feasible in terms of your budget. And then you would stipulate that that fee is payable at a later date. So often those dates we would look at is first day of principal photography or last day of principal photography, or a split between those two. Again, all these terms are essentially commercial negotiations between the party and would really be dependent on what the facts on the ground are for that particular production, in particular in relation to the financial position and the finance for that production. The second element of the fee that I spoke about is a share of the producer's net profit share. So sometimes you might find that the producer doesn't necessarily have the ability to pay a massive capital amount. So they will offer a writer 50,000 Rand as their capital amount of their writing fee, but then they will also offer them a percentage share of the producer's net profit share from the production. And what this means is, for the example, this amount is usually somewhere in the region between 2 and 2.5% for a writer. If the producer goes and finishes the production, sells the movie on, and can repay all their financiers who have lent funding for that production, and they now sit in a position where they start to make a profit from any future sales. Any profits that is derived by the producer, the writer then gets 2% of that amount. So as you can see, it allows a producer in the circumstances where they don't have funding up front to say, we'll give you the 50,000 Rand as your general fee, as your capital amount fee, but then we'll also offer you a percentage share of what is sometimes called back end. And that might then also incentivize the writer to take this production on and take on that writing service. Likewise, we will also look at giving them a credit. Stock standard, everyone understands this, but it's often important to set out exactly how that credit is going to be displayed so that the writer doesn't end up feeling, prejudiced to end where it's not particularly set out in the format that they would like. No disputes later if it's clearly set out in the agreement. And to go back to the most important element, we look at the rights granted. So as mentioned before, when you are contracting with your scriptwriter, you first prize want to do this on a commission basis, because as they are writing that script, they are developing the IP and creating rights. And we want to ensure that you as a producer always retain ownership of those rights. So we would include quite an extensive rights granting clause in that option agreement so that it is absolutely crystal clear to both parties that all rights created in the rendering of the services are always retained by the owner. There are also other sub-clauses that usually get included there. Depending on who your scriptwriter is, you might want, as a producer, the right to utilize their name and image in relation to your production as an advertising feature. So we will usually include those types of sub-clauses as part of the rights that are granted by the scriptwriter. We also like to ensure that it's not just what they're creating now, but any rights that may arise in the future from that script are also holistically transferred over and assigned to the producer, so that we don't in the future ever sit with an issue where a scriptwriter comes back and says, well, there's actually a new form of right that's run off from that script and I actually want to have a piece of that pie. The third agreement that I mentioned in the chain of title is the director's agreement. So obviously this is concluded between your production company or your SPV and the director that you're going to look for to utilize in the production. So as I said, it's not always included as part of your chain of title, but most of the time we like to include it and have that agreement ready and waiting to be signed by the director up front. Because if a director is brought in a relatively early stage of the development of the project, of the production, that director is more than likely going to be contributing from a creative perspective. They might be sitting down and looking over the script and giving input on that. And all of that input, again, is developing that script, and that is the creation of IP. So they can turn around at a later stage and say, well, if we look at the final script that's going to be used for production, I put about 10 or 15% of the work into the development of that script, which means that I own about 10 or 15% of that script. So again, we want to ensure that when we're contracting with a director, it's done on a commission basis, and all the input from a creative perspective that they're putting into the production as a whole, and in particular to scripts, etc., is all done on a commission basis, and that work all ultimately is owned by your production company. So if we look at the specific terms that are included in a director's agreement, It's very similar to your writer's agreement, except that your services are different. So we're going to look at exactly what services are included as part of your director's responsibilities. We're going to particularly look at the dates. This is very important to determining, especially if your director sits in Joburg and you're in Cape Town, when is that director going to need to be here if you're shooting in Cape Town? What happens with their travel arrangements? Who's responsible for organizing all of that and paying for all of those costs when they travel? What class are they traveling in? All of these details get dealt with in these contracts to ensure that there aren't disputes at a later stage and your director ends up, crossing the arm and saying, well, I'm not coming down to Cape Town unless you fly me first class. You don't want to have that dispute, later on in your production when timing is quite an important element. Also included is obviously the fee. We, again, would be able to look at a specific structuring for the director when they're going to receive that fee, the capital amount, whether or not they are going to be receiving a portion, a share in the producer's net profit share, and likewise the credit that is going to be handed over to the director for their involvement. So once we understand those three agreements and why, which rights emanate from those agreements and why it's important to encapsulate all of those in proper contracts to ensure that the production company always holds the rights, we can start to understand the importance of the chain of title. So if we look at the development of the film, chain of title is absolutely integral. You're almost wasting your time going through with the production if you don't get the chain of title in place at the right time and get those contracts concluded, because you're going to face a situation where there's disputes afterwards. You might have a fallout with one of your writers. You don't have your script writers agreement in place. Suddenly you have someone who really likes your project and actually wants to fully finance it, but they want to ensure that you've got your chain of title in place and you actually hold the rights, all the rights, to ensure that you can produce this. But you can't show that because now you don't have a script writers agreement with the party that you're now having a fight with. And that party knows that there's funding coming in. So what do? They want more money. So it's absolutely imperative that you get these contracts in place at the right point in time. Without having those agreements in place, you simply cannot prove that you hold all the rights to produce the film. And as mentioned, if you don't have the ability to prove that, it's going to be immensely difficult for you to obtain any finance or funding for your film or to sell and distribute your film, because that is the first question that your financiers and your sales agents and your distributors are going to ask. Do you have your chain of title in place? And you have to be able to present them copies of those signed agreements in order to prove that. So now that we understand chain of title, we can look at what happens to the rights after the development. So we've taken our option out. We've appointed our script writers. We've appointed our director. Everybody is very busy working on developing those rights to get a finished script, something that we can actually utilize for the production. And once we've got all that, we exercise our option. We now take ownership of the rights from the author, and we can actually go ahead and produce our film. We've got our funding in place. Everything, the money starts coming through. We can start pre-production process. We can then start the production process and commence principal photography. We can shoot our film, we can wrap, and we can have a finished product that's now ready to be sold. What we have to look at is that finished product, the film, because that in and of itself is, again, a separate piece of IP. It's a separate legal right. So if we look at that element, it's massively important, again, to understand that chain of title, where the rights started, how they were developed, and who contributed to actually making now the finished product, the film. And this is where what we term production legals comes into play. And your production legals are all your agreements that are signed with third parties who are involved with the production on the ground. So, as I mentioned before, when it comes to production legals, there's literally a list of contracts as long as my arm that have to be concluded, depending on obviously what's involved in your production. So cast, crew, locations, stunt, all your vehicles that are being hired, your picture vehicles, your behind the scenes vehicles, your stunt vehicles, if you're going to be using airplanes, if you're going to be using boats, drone agreements, security for your production, your location sites, your catering, your stationery. The list goes on and on and on. Water suppliers. As you can imagine, it's an immensely long list of people that are involved with the production, but it is vitally important that each one of those parties signs a contract with the production company. And first and foremost, that contract gets signed before they actually commence work on the production. Now, this is where a lot of producers actually fall short. They might have the chain and title in place, but when it comes to actually on the ground production, they are either reluctant to pay legal fees in order to get those agreements in place, or they nab those agreements from a previous production and take the cowboy approach and just run it themselves without having proper legal advice or protection on board. Or they just don't sign those agreements at all. And they go, well, I've worked with this guy before, I really trust him, blah, blah, blah. Only to find out at the end that when they come to trying to sell their film, the sales agent and your distributor are going to want to see all those agreements, because those form part of your rights. Each of those parties that is involved with the production actually are adding to the film. They are creating rights in their involvement. So, I mean, of most importance, you can understand your cast. Your cast are the faces on the film. They are in front of the screen. So if you don't have a proper contract in place with them, which again stipulates that they are working on a commission basis, it's a work made for hire basis, the rights to the work that they are creating is always owned by the producer. Then you're wasting your time. You might as well not produce, because those parties can all come back at a later date and say, you're not allowed to sell this. I'm not agreeing to you selling this. And you would then have to try and negotiate with them after the fact to get those contracts in place in order to be able to actually go and sell that production. So it's massively, massively important to get those agreements in place upfront and signed. It's no use sending the agreements through if you don't ensure that they are actually signed by the parties and sent back to you and kept on file. So, as mentioned, those production agreements are signed with each contributing party involved with the production of the film, and we ensure that those the rights created by those parties are owned by the production company, by ensuring the correct provisions are put in place in those contracts stipulating that it's commissioned works made for hire, all rights are owned by the production company. So if we have to look at the important clauses in those production agreements, first and foremost, we can look at your confidentiality clause. This is a massively important clause because you want to ensure that those parties involved in the production don't run around filming what they're doing, filming your sets, taking photos, and then uploading those to social media, really giving away the gist of your whole production, and essentially disclosing the rights that you've now paid for, not only acquiring but developing, and the rights that you hold. So we want to ensure that those confidentiality provisions are absolutely strict and enforced, and that your parties that you're contracting with are fully aware of that and know from the outset that they're not allowed to do that. It's no use those parties finding out afterwards, once they've already posted something to social media, that they weren't entitled to do that. They needed your permission, for example, in order to do that. So that's a massive, massive clause in each of those agreements. Again, of equal importance, if not more, is the grant of rights clause. And this is the one where we set out that all the work done by those parties in relation to the production are done on a commission basis and will at all times now and in the future be owned by the production company. Another clause that is of interest and gets argued quite a bit, should I say, is the clause that indicates that the parties are being appointed as independent contractors. So to clarify, when it comes to employing a third party to provide a service, there are two ways of going about doing that. The one is to employ them as an employee. The other is to appoint them as an independent contractor. Now, there's quite a big difference between those two. So essentially, if you're a company and you need someone to be your office administrator starting today, but for the foreseeable future, that is a role that you would usually employ somebody to do, because it's going to be a service that's going to be rendered on an ongoing basis, so long as your company exists. But in doing so, there is specific legislation in place that governs the employment of persons and dictates what you are allowed to do with an employee and what you're not allowed to do with an employee, what you're required by law to provide to an employee and what you aren't required by law to provide to an employee. So an employee is a much more difficult role and a more costly role to have in a company than an independent contractor, because you have to offer, for example, leave to an employee. Their salary is a set salary. You don't really get to deviate from that salary unless you have justifiable reasonings for it. You cannot terminate that person's employment unless you follow very strict procedures set out by our law. On the flip side, an independent contractor is someone who works primarily for themselves. So unlike an employee who will work exclusively for your company, will be based at your office and generally work there from 9 to 5, an independent contractor is not subject to those terms. An independent contractor might work for you for this month and might simultaneously be going to work for somebody else and providing services for somebody else. They will usually dictate their own terms or times of services, but that's really dependent on exactly what those services are. But they are not an employee from a legislative perspective, which means that you can set your termination provisions. You don't have to follow the termination provisions that apply to employees, such as disciplinary hearings, etc. You can terminate on an immediate basis if your contract provides specifically for those terms. And most importantly, you don't have to offer leave. There's no set salary. It's an agreed fee. So it's much easier to manage an independent contractor. But where independent contractors are important from a production perspective is that you are working on a specific project. An independent contractor is going to come in and fulfill a specific role, provide a specific service for that project. But once that project is finished, that role becomes redundant. You no longer need those services. So most parties, from a production perspective for a specific film or TV series, are appointed as independent contractors. So they will come in, render their services, be it as a cameraman for you, for this specific production. And when this is finished, they have the right to go off and do that for somebody else. And they can negotiate their fee on all those productions. There's no set salary, there's no leave elements. They can dictate when and how they want to take their own breaks. If they don't want to work for 3 months, they don't work for 3 months. So it's important to understand the difference between those two roles. We often find that, especially if there's a grievance between the producer and a member of crew, for example, and let's just say that crew member hasn't fulfilled their roles and has breached their contract with the producer and the producer terminates, that crew member will run off to the CCMA. The CCMA is a body that is specifically set up to govern employment scenarios. And why I'm telling you this is because your independent contractors are not entitled to utilize the CCMA. The CCMA does not govern independent contract agreements. So where these crew members or cast or whatever the case may be that are appointed as independent contractors are going to the CCMA, it's actually incorrect and they aren't entitled to do so. So it's vitally important, again, from the contract perspective, to ensure that it is clearly set out that those parties are not employees, that they are appointed as independent contractors. And in doing so, we set out specifically that they are responsible themselves for making payment of their tax. Unlike an employee, the company is responsible for PAYE every month for that employee. With an independent contractor, it is actually the independent contractor that is responsible to ensure that that is paid. Practically on the ground, you will find that a production company will have a payroll company appointed, and the payroll company will actually pay that tax on behalf of the independent contractor. But that is more a structure of convenience than the obligation actually resting on the production company to do that from SARS's perspective. So, to draw all of this together and go back to understanding film and television production as a business, we can look at what we've kind of gathered from all of this. So we now understand the structure of a business, and in particular a company, and who gets to register a company, how it gets registered, and what information is involved with registering a company, and the benefits and obligations of having a company and operating through a company as opposed to operating in your individual name as a sole proprietor. We then had a look at what are the assets of the company. And as mentioned, with production, what we're looking at is IP, intellectual property. Those are the assets that you are going to be dealing with in your business. We then assessed how and when those assets are created and acquired. We looked at when does copyright come into play, how is it protected, and how do you transfer those rights from one party to another for a fee in order to generate an income. Important, massively important, in fact, is the chain of title and your development of production. And we looked at how those assets, the IP rights, are encapsulated in each one of those agreements in order to show where they started and how they were developed and those rights built on in order to create your finished project or product, the film. And each of the contracts involved in that process and how the rights are dealt with, most importantly, to ensure that you as the producer hold those rights from the initial creation right through to the end, to the production of the film, so that you are able to confidently go forward and show, I have the full package of rights. I am lawfully entitled to raise finance against that and lawfully entitled to actually go and sell and distribute that without infringing anyone else's rights and benefits. So we also looked at the on-the-ground production and the production legals that are involved in creating that finished product, the film. The next step in the process is to understand how to then finance the development and production of your film, and ultimately how to sell your film and get it distributed, because that, at the end of the day, is where you're going to make your money. So the elements of finance, sale and distribution will be dealt with by my fellow director at Irish McLeod, Guy McLeod, and he will be dealing with all of these elements in the next presentation. So thank you very, very much for joining in and listening to us, giving us a chance to offer you some information on the legal side of film production. We really do enjoy offering these webinars and seminars to emerging filmmakers. We find it massively important that you understand what you're actually doing on a day-to-day basis from a commercial perspective and a legal perspective, so that you can make informed choices, so that you can get the right contract signed at the right point in time and know that your production process is going to be smooth. It really helps to have all of those ducks in a row so that you know when it comes to getting your finance, if someone asks you for a document, you have it, it's there and ready, you can present it, and that'll help you get your finance and ultimately help you sell and distribute your production in order to make a profit from that or generate an income from that. So if there's one thing that I can emphasize to all of you today, please ensure from the outset when you start working on a project, whether you are the producer or you are the writer, take the correct advice. Approach an attorney who specializes in this industry and understands all of these rights and how they come together. Get the advice from them as to what agreements you need to get in place. We aren't all scary. We really do like working with creatives and trying to get these projects off the ground. And as much as it does cost money to get agreements drafted, we're all there to really try and help you as far as possible and offer some advice, even that if it assists you from the outset and knowing what you need to get in place, and you can get that funding together in order to pay for those agreements at a later stage. We're always happy to offer the advice and try assist you in understanding this process and make sure you get the process under wraps. And getting those agreements properly drafted from the outset is vitally important. I mentioned it before, but there really is no point in undertaking these productions if you don't have your rights wrapped up and proper contracts in place between all the parties, because you're going to do all this hard work over the course of many years often, only to find a hurdle right at the end where you've got a party that was involved potentially many years before, but is now holding you at ransom and preventing you from actually producing your film or ultimately selling it because they hold those rights and they haven't been obtained from them up front. So please, if you have any questions on anything that I've discussed in this presentation, likewise with Guy's presentation to come, you're welcome to contact us. I will ask Wesco just to put our information out there, our email addresses, so that you can contact us with any questions. We will furthermore be offering a Q&A session in writing. So once you've watched these presentations, make notes as you go through. If there's any questions that you have, you're welcome to jot them down and send them through. Wesco will obviously then take those all in and send them through to us. We will present then our written responses, and we'll have that distributed to all the participants in this presentation, so that you can all see what those questions were and hopefully gain some further insight. Thank you very much for your attendance and for watching, and we really do look forward to working with you in the future. Thanks very much. Bye. Okay, Nadia.